You by Jetstar, the world's best low-cost airline. Now flying to more than 25 holiday destinations at home and overseas. Visit jetstar.com now.
And what a beautiful glistening morning in Hobart. Fine and 23 degrees and a sunny weekend on the way as well. That just looks magic there, doesn't it?
It does.
It's 8:18. It's time for Sunrise in Focus, and Victoria Police are calling for a ban on internet blogging about accused arsonist Brendan Socolac.
Yeah, court has stopped the publication of some of his details, but it appears anyone has been able to access some of this information on the web. So a law's lagging behind technology. For more, we're joined by criminal lawyer David Galbally and social network strategist Laurel Papworth. Good morning to both of you. David, if I could start with you, do laws on the internet need to be changed, and how would this be done?
Well, we need to have a law that makes the internet, the website provider, responsible for what it is that is being displayed on the internet, particularly in circumstances that breaches or tends to breach a court order.
So how do you monitor it, and also what are the legal ramifications for posting something that isn't allowed to be there? So, for example, we know there is a suppression order in place and certain information about someone's not meant to be revealed, but, you know, as Mike was just saying, it's all over the net.
Look, it's not going to be easy to be able to enforce it, but where you have a court that says you can't publish the picture or the address of an individual for whatever reason, the internet provider or the website provider, for instance Facebook, should be responsible for what it displays on the internet. Now, Facebook say they're not responsible, but that's wrong, and it's a nonsense. They're displaying it in a jurisdiction that breaches an order. They should be liable.
And yet, Laurel, you say it's not possible to regulate the internet.
It's not possible, and I think having a law that is not enforceable is a waste of time and money.
But should it be enforceable?
I have to disagree.
All media out. Oh, sorry, David, I'll let you go.
I have to disagree. It is possible because already we have police throughout the world that monitor the material in relation to child pornography. And as a result of monitoring that material and the downloading of that material, they've made a lot of arrests over the last 5 or 6 years.
Yeah,
so
but I don't
possible.
think that people are discussing pornography and pedophilia material at the pub and at the footy. So whatever we do in offline communities, for instance, at the pub and at work, which is discussing the bushfires and discussing a suspected arsonist, particularly in a closed community, then people will naturally do that on Facebook as well. And what happens on Facebook is people forget about the invisible audience. So they'll be on, not just on groups specific for the bushfires, but they'll also join knitting groups and football groups on Facebook, and they forget about the fact that there's 4.5 million Australians on Facebook that might be seeing what they're discussing and what they're talking about.
But should they monitor? I mean, we don't want to jeopardise a case. Just as the media is not allowed to broadcast details, newspapers aren't allowed to print it in Victoria, television isn't allowed to show details in the state in case there's a jury that's going to be called. Should it not be monitored? I mean, nobody wants to be responsible for jeopardising a case.
I totally agree. I mean, I have a question about whether there's an Australian out there that doesn't know about the bushfires, and if there is, whether they should be on a jury or not. And if they are, then they probably know that they were set by an arsonist. There's discussions all the time that happen both online and offline. The real issue is it's not so much whether there's a fight about what they reveal, but people might accidentally say, I used to go to school with that guy, or I live next door to him. Is that against the law because they said it on Facebook rather than saying it in an open discussion at a football?
Well, David, let me ask.
You have to realise that anything that's put on the computer, on Facebook, is open for anybody to access. So the people that run Facebook have got to be responsible for what's published. And just because we say that it's meant to be a private conversation on Facebook, the fact of the matter is it's not, and it's not an excuse to allow that medium to breach the law.
So just give us a couple of examples of how information that could be released could influence a fair trial.
Well, take, for instance, if the police are, for the moment, continuing to take statements from witnesses that say that they could identify an individual lighting fires and are getting a description of that individual, if on Facebook there is a photo of that individual, then the witnesses may well be affected by the description they give by looking at that and accessing the photo.
Only if they live in Victoria, if it's a Victorian alleged arsonist.
Correct.
So how do you lock Victoria out? How can the rest of the country see this information, as they should?
Well, it should be shut down in Victoria. It should not be allowed to be accessed in Victoria. We should have a mechanism by which we can shut it down in Victoria. And if we can't do it, then we ought to be looking at being able to protect our people who are charged with offences from having trials placed in jeopardy because of what's published on the internet in breach of court orders. Otherwise, why have the court orders?
And what happens if these people have created their own Facebook pages or their own MySpace pages and then they end up in court?
But that's meant his or somebody's, it's often shut down. I know that's where Facebook will often step in and shut those down.
Yeah, but if he's created it himself?
They should shut it down. No, the Facebook providers should be responsible for what is put on Facebook. They say in their terms and conditions when you enter Facebook that they're not responsible. Well, that's wrong. They should be responsible. Newspapers, television stations are responsible for what they publish. Why shouldn't the Facebook providers also be responsible?
And what happens here, I think, quite often is that when you do shut it down, people take it elsewhere. So they'll say, my Facebook group was shut down, I'm going to take it to MySpace, I'm going to take it to niche networks, I'm going to take it to Twitter, I'm going to take it to... And you end up, instead of one copy of that information, it'll end up 100 different places, thousands of different places.
Just because it seems difficult doesn't mean to say that an attempt shouldn't be made to enforce the law and to protect the position of people who would ultimately be standing trial. It's no excuse because it might appear to be too hard to say, well, it's too hard, we can't do it.
But also not to compromise our need for freedom of information either.
Oh, I agree with that, certainly. But where you have a court that's made a court order, all attempts should be made to preserve that court order until it's lifted.
Sure.
All right. Well, look, it's a fascinating discussion, and like a lot of things with technology as it emerges, we set precedents, we have cases that will regulate things, so we'll see what happens. David Galbally QC, thank you very much for your time. And Laurel Papworth, thank you for joining us as well. Really appreciate it. And let us know what you think. Drop us an email or an SMS with your views on that one. 8:25. Now, how much do you think couples are spending on